Welcome back to Lawyer Stories. Today I want to delve into a recent consultation that came through our firm, highlighting a common yet often overlooked aspect of employment offers, the true value of total compensation. It's a tale that serves as a powerful reminder for anyone navigating the complexities of career changes, particularly here in the United States, where benefits often carry significant financial weight. Our client, let's call him John, was understandably excited. He'd just accepted a new position with a prominent company, a step up in his career, with significantly more management duties and a promised $20,000 increase in his annual salary. This was, on paper, a substantial raise that promised to significantly improve his family's financial standing. John had, to his credit, attempted due diligence. He'd reviewed the benefits summary provided during the offer stage and found the costs as presented to be acceptable. He believed he had a clear picture of his take-home pay. The reality, however, hit with his second paycheck. The figures on the stub were jarringly different from his expectations. Instead of seeing a significant boost reflecting his $20,000 raise, his net take-home pay had increased by a mere $100 per paycheck, plus a few cents. This was a fraction of what he anticipated. John's immediate reaction was confusion, quickly followed by a sense of dismay. He reached out to our firm, seeking clarification and, frankly, hoping there had been some administrative error. Upon reviewing his documentation and comparing it to the actual deductions on his paychecks, the picture became clearer, though no less frustrating for John. The primary culprit was a substantial increase in his healthcare costs, driven mainly by what his new employer termed a spousal fee. While his previous employer had covered his spouse's health benefits without an additional charge, his new company had a policy of imposing a significant fee for spousal coverage across each benefit program. This is a practice that, while common, is often buried in the fine print and can vary wildly between employers. We've seen many instances where companies might cover 100% of an individual employee's premium, but then require substantial contributions for spouses or family members. Some even implement an additional surcharge if the spouse is eligible for coverage through their own employer, regardless of the quality or cost of that alternative plan. For John, this spousal fee, coupled with higher baseline premiums than he'd been led to believe, instantly eroded a substantial portion of his anticipated raise. His previous premiums were around $91 per biweekly check. The new ones, with the spousal fee, shot up to approximately $370 per check. Annually, this represented over $7,200 in unexpected out-of-pocket costs just for health insurance. But the surprises didn't end there. John also recalled a verbal confirmation during his interview process that the company contributed to health savings accounts, or HSAs. This was a significant draw for him, given the tax-advantaged savings and investment opportunities an HSA offers for future healthcare costs. Unfortunately, this verbal promise proved to be hollow. The new company did not, in fact, contribute to HSAs. This meant John was not only facing higher immediate out-of-pocket costs for his insurance, but also a significant long-term loss of what he had understood to be an employer-matched benefit, a benefit that for many can effectively act like an additional tax-free retirement vehicle. The compounding effect of these unforeseen expenses, combined with adjusted tax withholdings for his higher income, meant that his $20,000 annual raise, which should have translated to around $530 extra per bi-weekly paycheck after standard tax estimations, dwindled to a mere $100. It's important to clarify the tax burden aspect here, as it's a common misconception. Our progressive tax system means that only the additional income earned above a certain threshold is taxed at a higher marginal rate, not the entire salary. So earning more money will never, in itself, lead to a lower net income due to taxes. However, higher income does lead to increased withholding, and if one's W-4 isn't adjusted, or if there's a mid-year job change, the initial paychecks might reflect an over-withholding, which would eventually be rectified as a tax refund. For John, this was less about the overall tax liability and more about the immediate impact on his cash flow, combined with the substantial benefits hit. From our legal consulting perspective, John's situation, while regrettable, is not uncommon. Many employers, particularly in a competitive hiring environment, may provide benefit summaries that are either outdated, generalized, or simply lack the granular detail necessary for an accurate comparison. They might view detailed cost breakdowns as proprietary information and be reluctant to share them until after an offer is accepted. However, in John's case, the specific verbal misrepresentation regarding the HSA contribution, coupled with the demonstrably outdated benefits summary he was given, presented a stronger basis for action. While a general buyer beware approach to employment contracts is always prudent, a direct misstatement of benefits and the provision of incorrect cost information venture into a different territory. Our advice to John focused on a multi-pronged approach. Firstly, we recommended a formal, yet calm and factual communication with his new employer's HR department. This was not to be an accusatory tirade, but a professional presentation of the facts. The discrepancy in the HSA contribution promise, the outdated benefits cost sheet he received, and the significant financial impact of the previously undisclosed spousal fees. The aim was to open a dialogue, to highlight that his decision to accept the offer was based on incorrect information, and to explore potential rectifications. This could range from a direct salary adjustment to offset the missing HSA contribution to a re-evaluation of his benefit enrollment options. Secondly, we advised John to thoroughly explore alternative healthcare options. Could his spouse obtain more cost-effective coverage through her own employer if available? Many couples find that maintaining separate employer-sponsored plans is, counterintuitively, more economical than consolidating onto one, especially given the rising prevalence of spousal surcharges. Moving his spouse to her own plan, if feasible, would significantly reduce his current deductions. Finally, we discussed the longer-term perspective. While the initial disappointment was palpable, John now possessed a higher baseline salary. This, in itself, is a valuable asset for future career moves. Equipped with a far more comprehensive understanding of total compensation, he could leverage this higher salary in future negotiations, ensuring any subsequent opportunities genuinely align with his financial expectations. He was also advised to adjust his W-4 withholdings to ensure future tax deductions are more accurate, mitigating the temporary impact on his take-home pay. The key takeaway from John's experience, and a lesson we impart to all our clients, is the critical importance of evaluating total compensation, not just the base salary. This encompasses not only health, dental, and vision insurance premiums and deductibles, but also employer contributions to retirement accounts like 401 kiloseconds and HSAs, vesting schedules, paid time off, sick leave, and even commuter benefits or tuition assistance. Always ask for a detailed, current benefits cost sheet in writing, and don't hesitate to press for specifics on spousal fees or employer contributions to any benefit. If a potential employer is unwilling to provide this transparency, it can be a red flag. In John's specific case, armed with the documented discrepancies, he now has a stronger position to advocate for himself. Whether this leads to a renegotiated compensation package or simply a more informed strategy for managing his family's finances, it's a powerful reminder that in the complex world of employment, the fine print often dictates the real bottom line. That's all for this episode of Lawyer Stories. Join us next time for another look into the intricacies of the legal world.